All right, good evening. Can everyone hear me all right? Yeah? All right, great, fantastic. If you don't mind, I would like to first begin with a moment of silence for the family of Eric Garner, which would include his widow, Esau Garner, their children, Eric and Erica, their grandchildren, and their extended family and friends. So if you would just join me in a moment of silence, please. All right, thank you. Good evening to all of you. Thank you so much for joining us. My name is Samuel Roberts. I am director of the Columbia University Institute for Research in African American Studies. IRAAS was founded in 1993 by the late Dr. Manning Marable with the mission to, quote, envision, engage, and transform, end quote, the world around us. It is my pleasure to welcome you to this month's event in IRAAS's public event series, which we have simply called Conversations. This title indicates its main purpose to bring visionary thought and practice leaders into engagement with you, our IRAAS family, to have discussion about how we might move forward and transform the world all around us. You may find information about future events, of course, at www.iraas.com. That's IRAAS.com. The title of tonight's lecture, What is the Monetary Value of a Human Life?, has particular resonance for us tonight. This is not because there is or actually should be an answer to that question. Of course, a human life is invaluable. A human life is precious. It is priceless. However, if you were to drop the word monetary from the title of tonight's talk so that it would read simply, what is the value of a human life? Our nation's police officers and our nation's courts appear to have devised an answer of their own. That answer would say not much. Life, apparently under the force of individuals and systems supposedly put in place for our protection to keep the peace, may be taken simply for standing up to police harassment, apparently. If you think that I might be exaggerating, that I might be being hyperbolic, I would remind you that Eric Garner, before he was murdered on the streets of Staten Island, had just broken up a street fight between two other citizens. That, dear friends, is a fact. With that fact, I ask you to imagine what if, instead of taking Garner's life, Officer Daniel Pantaleo and his colleagues had told Garner, our job is to protect life and to keep the peace. You, sir, in stopping the escalation of a violent fight, have therefore made our job that much easier. Perhaps none of that would have happened. None of those events leading to his death would have happened. I won't say anything about the stupidity of a system that encourages police officers to use brute and lethal force upon anyone who dares to ask the question of why he or she is being harassed. I won't bring up the point that Eric Garner no fewer than 11 times literally begged for air, begged to breathe, begged to live. I will instead take first principles first. If our cities and many other cities' policy of quote-unquote broken windows policing is supposed to be informed by a philosophy of community policing in which officers maintain peace and respect for life, this certainly cannot be it. I have to confess that I considered earlier this morning asking tonight's speaker, Dr. Michael Ralph, to reschedule tonight's lecture to next year. I decided against it. Michael and I had scheduled this event over the summer, in fact, before Eric Garner was killed and well before yesterday's grand jury verdict. However, it was clear to me this morning, after much soul searching, that we need this discussion now more than ever. We need a historical and a thoughtful consideration of exactly, to paraphrase his title, what is the value of human life? I thank you, Michael Ralph, for joining us I thank you all for being with us here this evening. As I mentioned this evening, our guest is Professor Michael Ralph of New York University. He teaches in the Department of Social and Cultural Analysis at New York University. He holds a PhD in anthropology from the University of Chicago. Michael's research centers on risk, injury, liability, citizenship, and sovereignty in the cities of Dakar, Senegal, and New Orleans, United States, making him truly an international and particularly a transatlantic scholar of the Black experience in the world. He's published in Disability Studies Quarterly, Souls, Social Text, Public Culture, South Atlantic Quarterly, the Journal of the History of Sport, and Transition. He is the editor of Transforming Anthropology, the flagship journal of the Association of Black Anthropologists. Michael is also a member of the Souls Editorial Working Group, the Social Text Editorial Collective, and the editorial boards of Sport in Society and How, the Journal of Ethnographic Theory. Please join me this evening in welcoming Professor Michael Ralph in his talk this evening, What is the Monetary Value of a Human Life? Thank you.
Thank you, Dr. Sam Roberts, for your very thoughtful introduction, insightful introduction. So today, as you can see, and as Sam mentioned, the title is Monetary Value of a Human Life, or What is the Monetary Value of a Human Life? And while it doesn't deal explicitly with the concerns that Sam raised, it does address them. It does draw them into conversation with some of the issues I'll be discussing. And I guess I realize that the monetary value of a human life is something of an abstract concept, so I'll begin with some sort of visual illustrations. In a popular series of State Farm insurance commercials, Los Angeles Clippers all-star point guard Chris Paul is reunited with his fictional brother, Cliff Paul. In one sense, their lives couldn't be more different. One is a famous athlete, the other works in what some people consider to be the world's most boring enterprise, insurance. And yet State Farm would have us believe that what they do is essentially the same.
And yet, a new question
Daddy, where does this come from?
rendered them speechless. As the Pauls delved deep into their lineage, they discovered something extraordinary. In 1922, local shopkeeper Clifford Paul, Sr., inspired employees at State Farm, a thriving new insurance agency, to be there for customers like a good neighbor. While Christopher Paul, Sr., revolutionized the game of basketball by suggesting players pass the ball to other players who could then score. Delighted that their ancestors invented the assist, the twins could rest assured the gift of giving was in their genes. Allegedly. Nothing endures like the legacy of an assist.
All right, in this formulation, insurance is a benign force that helps people recover from hazardous scenarios that are impossible to anticipate. In practice, though, obviously, capitalizing risk can have unsavory implications. On August 25, 2011, NBC reported a scheme that former U.S. presidential candidate Rick Perry had concocted in 2003 while he was governor of Texas to take out life insurance policies on retiring public school teachers through the Swiss financial firm UBS. This was nearly 6 months before UBS would make news again as one of the corporate entities entrusted with some of presidential candidate Mitt Romney's Swiss accounts. The rationale behind Perry's indecent proposal was that these aging public school teachers had a high statistical probability to die within the next decade. When they did, the government of Texas stood to turn a profit. Michael Moore examines a similar practice in his 2009 documentary, Capitalism, A Love Story, through the devastating revelation that a number of Fortune 500 companies have reaped immense profits from insurance policies they held in their employees. When Daniel L. Johnson died of cancer, Moore tells us, M&G Bank made more than $5 million on policies it had taken out in his name that were never shared with his dependents. In fact, Johnson's widow only discovered the policy when the insurance company sent the check to the family home by mistake. There's a reason that it's illegal for me to take out a fire insurance policy on your house, Moore insists, incredulous that anyone could provide corporations with incentives to have employees die in accordance with their policy projections, as he puts it. Yet the practices Moore finds so dubious occur far more often than we realize, and they are not limited to corporate investments in human lives. Joseph Caramadre, pictured here, is a successful lawyer and financial planner by any standard. A Rhode Island native from a modest Italian-American background, Caramadre first earned a certified public accounting degree, then saved money to earn a law degree in night school. Caramadre's drive is readily apparent in his unusual appetite for detail. He has earned millions of dollars as a lawyer who exploits the fine print in tax law on behalf of his clients as well as himself. Grateful for his success, Caramadre is a philanthropist, donating much of his fortune to the Catholic Church and to charitable organizations that make it their mission to help young people who remind him of his own youth, young people from low-income and working-class families. Caramadre is also the subject of a 66-count federal indictment involving the fortune he made from other people's life insurance policies. The secret to Caramadre's financial success turns on the intimate details of a policy offered by the multinational Dutch banking and financial services firm ING, a package known as the Golden Select Variable Annuity. One of the multi-trillion-dollar financial services industry's most popular products, the variable annuity has two parts. First, it provides consumers with options for investment that work like stocks, bonds, or mutual funds depending on their particular tastes. This is why these funds are described as variable. Unlike mutual funds and other standard investment options, taxes on variable annuities are only charged when the client formally withdraws them as cash. This means the client can exploit changes in the financial marketplace by moving money from one investment fund to another without paying any sort of penalty. But the variable annuity also includes a guaranteed death benefit, a form of life insurance which guards against the possibility that a client can lose his or her entire fortune in the variable annuity. In the case of a client's untimely demise, her dependents receive a guaranteed payment equal to the amount in the variable annuity or the amount reserved in the guaranteed death benefit, whichever is greater. Predictably, these annuities are marketed to people nearing retirement. In the first decade of the 21st century, life insurance firms made more than $1 trillion selling policies that promise financial security to families grappling with the death of a loved one. Caramadre's genius is that he figured out a way for people to make good on their guaranteed death benefit while they are still alive, by having them sign their guaranteed death benefits over to him in exchange for a fixed amount of cash up front. Naturally, this offer was especially tempting to people who might have extravagant medical bills or who might have plans for spending the money they had saved before they died and could no longer use it. Caramadre typically paid between $3,000 and $10,000 to dying people holding variable annuities, formerly known as annuitants. In more than a decade of hustling annuities, Caramadre and the team of employees he eventually drafted in order to keep up with his business made so much money that prosecutors are pressing him to repay $46 million of his earnings. There's something no doubt unsettling about the idea that Caramadre and his team made tens of millions of dollars from other people's life insurance policies. It is perhaps for this reason that angry dependents have peppered him with a number of lawsuits and an even greater number of insults. Still, several judges and legal experts that have reviewed the evidence have concluded that Caramadre did nothing illegal by way of insurance law. If anything, Caramadre might perhaps be convicted of having misled some of the terminally ill people with whom he and his colleagues interacted. In other words, Caramadre is being charged with duplicity, not with profiting from another person's property, another person's life. Speculating on another person's demise is a tradition many centuries old. Such practices have historically included wagers on the life chances of indigent people Other examples include speculation concerning the mortality of aristocrats or the outcome of capital legal decisions. The widespread practice of profiting from another person's misfortune, even death, had historically led many polities to ban life insurance entirely, most notably through a British statute known as the Gambling Act of 1774. Also known as the Assurance Act of 1774, this legislation outlawed the practice of affixing a monetary value to another person's life, except in cases where the person insuring shall have an interest in the life or death of the person insured. But in wading through Rhode Island insurance contracts, Carl Madre had discovered that, in contrast to the laws governing insurance in most states, there was no stipulation that the bearer of a policy has an insurable interest in the person insured in the state of Rhode Island. Instead, the basis for the policy was called the measuring life, or the store of value on which the annuity was based, was simply construed as a form of individual property that could be legally transferred to someone else. All Caramadre and his associates had to do was convince the annuitants to sign over the rights to this property in exchange for money up front. Caramadre's commercial acumen understandably fails to resonate with families still reeling from the loss of a loved one. Stephanie Porter, whose mother sold her guaranteed death benefit to Caramadre for $2,000 before she died of cancer, says bluntly, "It's slimy what the man did." And yet the case of the United States of America versus Joseph Caramadre has merely raised the profile of a practice that has a much longer genealogy and which is rather more widespread, the fact that a person or firm can indeed generate legal revenue from affixing a monetary value to another person's life. In recent years, news outlets from the Huffington Post to Wall Street Journal have drawn public attention to the fact that a number of Fortune 500 companies, including Bank of America, Citibank, McDonnell Douglas, Hershey, Nestle, Walmart, Procter & Gamble, and American Express, have all made use of what industry insiders call corporate-owned life insurance, elsewhere known as janitor's insurance or a dead peasant insurance. These are insurance policies for which firms are the beneficiaries rather than an employee's dependents. For surviving family members, the outrage stems in part from the fact that they did not even know about these policies that sometimes pay several millions of dollars, yet go directly to the employer. Others are disturbed because, in their view, the idea of speculating on another person's life is a primitive custom that all but vanished with the Assurance Act of 1774. But we should take a minute to recall that the Assurance Act of England outlawed the practice of speculating on a free person's life. It said nothing about attempts to affix the monetary value of a slave or a debtor, a practice that we can trace back as far as 1402. The same merchants concerned to insure their enslaved cargo would sometimes take policies on their own lives and those of family members in advance of voyages. The fortunes of free and enslaved people would appear to diverge centuries down the road. For this reason, historians of life insurance insist on treating slave insurance as a separate and distinct industry. Slaves in the antebellum U.S. were legally classified as property, they insist. As such, their worth was based on a subjective impression of their value, like that of other chattel. It was not based on projected life expectancy, they will say, the ultimate basis for life insurance policies in the U.S. and elsewhere from the 19th century forward. The pragmatic function of life insurance has, however, defied this neat categorization. In the time I have left, I'd like to propose that during the last few decades of legalized slavery in the U.S., slave insurance had already started to assume several characteristics that historians would later associate with the debut of life insurance. In the process, I'll also suggest that, in the aftermath of emancipation, the legal rationale of enslavement, including a calculus of value we tend to associate with slave insurance, came to govern the life insurance industry. For the idea of insurable interest, on which corporate-owned life insurance relies, is arguably an extension of the legal rationale that made it possible for a slave owner to insure his slaves in the first place. Excuse me. As mentioned before, merchants, especially those who undertook the hazards of seaborne travel, had long developed strategies to secure their lives against the possibility of peril. But the structure of the life insurance industry began to change more dramatically in the 17th century, with major transformations in scientific knowledge concerned with predicting human mortality. In 1693, Edmund Halley, best known for his pioneering study of comets, created the first known mortality table, which measured life expectancy along one axis and the average year in which a person of a given age had died along another. By use of this mathematical construct, insurers assigned differential coverage based on how long someone in a given demographic was likely to live. The London Society of Equitable Insurances on Lives and Survivorships would, in 1762, begin to base life insurance premiums on age rates. This was a crucial turning point because pricing insurance at consistent rates for people of varied age had historically discouraged younger people from contracting policies while aging and ailing persons sought them out. U.S. companies soon adapted life tables from British firms, and while a few life tables were long maintained as the industry standard, U.S. firms eventually hired actuaries to develop mathematical predictions of their own based on data unique to U.S. populations. The nature of life insurance changed even more dramatically during the 19th century with the rise of actuarial science and more sophisticated strategies for assessing the mortality of people within a given demographic. When abolitionist and future actuary Elizur Wright visited England in 1844, he was aghast to see men who could no longer afford to pay their insurance premiums step onto a block one by one to sell their policies to merchants interested in turning a fast buck. Wright decided this form of auction too closely resembled slavery. He vowed to develop a mathematical system for tabulating the value of a human life proper to the condition of a free man in U.S. civil society. In 1854, Wright shared with the New England Life Insurance Company his modified version of a British actuarial table. By 1844, the value of the English life insurance industry already exceeded £150 million. The net worth of life insurance in the U.S. during the same decade was a paltry $4.5 million. Yet in the next 2 decades, that figure would climb to $2.3 billion as the U.S. developed the world's most lucrative life insurance industry. The crucial question thus becomes, what happened in the U.S. between the 1840s and 1860s to reshape the way Americans understood human mortality to provoke a new repertoire of strategies for securing the future? In apparent consensus, U.S. historians have argued that life insurance took root at this juncture because scores of Americans were abandoning rural homesteads for urban employment opportunities, leaving behind the large agrarian households and community networks that had previously sustained them in times of crisis. These developments, coupled with the declining significance of the church as the primary arbiter of moral judgment regarding commercial matters, led many Americans to find security in emergent investment strategies like life insurance. Yet we might consider a parallel sequence of events that changed the way Americans had come to understand the monetary value of a person's life. Between the time that the slave trade to the U.S. was outlawed in 1808 and slavery was abolished in 1865, slave life insurance was a crucial element of industrial insurance, a key feature of slave shipping, and a central element of credit networks throughout the agrarian South. During this period, the nature and function of slave insurance was reconfigured. From an emphasis on slaves as cargo, merchants would eventually become interested in the value of enslaved workers and the unique skills they acquired in tandem with the birth of U.S. industry. In tracing the trajectory from slaves as cargo to enslaved workers, we might consider the prominence assigned to Captain Luke Collingwood's decision to jettison or throw overboard 132 slaves from the slave ship Zong during his 1781 voyage. Jettison marked a category for which insurers were not liable, though this was the first time such a practice had gained such widespread attention. And in a growing body of scholarship, historians have considered the pivotal role this seeming disregard for human life played in firing abolitionist sentiment. But as recent scholarship has suggested, the 1841 case of Thomas McCargo versus the New Orleans Life Insurance Company might present a more useful way to theorize the stakes involved with affixing a monetary value to a human life in the mid-19th century. This case involved the slave ship Creole en route from Norfolk, Virginia to New Orleans, Louisiana, down and around the East Coast, when 19 male members of the 135 slaves on board staged a successful uprising. They secured the ship and commanded the captain to sail to the Bahamas, as they were aware of an insurrection that had taken place the year before aboard a ship called the Hermosa. Those enslaved persons, upon arrival in the British territory, had been liberated. Though the enslaved persons above the Creole were virtually freed upon their arrival to New Providence, Bahamas, the case of Thomas McCargo versus the New Orleans Life Insurance Company took more than a decade to resolve, the crucial issue being whether or not a revolt amounted to a quote-unquote peril of the sea, in which case the insurance company would be liable. This legal quandary turned on the peculiar nature of enslaved property. In accordance with the 19th century notion that each man owned his quote-unquote capacity to work, and that life insurance by extension was about owning one's own risk, the revolt of enslaved persons upon the Creole was ultimately ruled as having testified to what was called an assertion of freedom. Citing this act of self-possession as evidence that these formerly enslaved persons were now the authors of their own activity in the world meant they were no longer slaves and thus no longer property. In other words, by seizing their freedom, it was ruled that these slaves had ceased to be someone else's property and could thus no longer be claimed as an asset in an insurance policy. In this way, the case of Thomas McCargo versus New Orleans Life Insurance Company articulated with the original idea of enslaved cargo that had defined marine insurance insofar as one man's right to own another was predicated on the compromised legal standing of the latter and not some inherent ontological property of the enslaved. At the same time, Thomas McCargo was part of a new moment when it became possible for people, especially in this enduring hierarchy of presumed commercial expertise, men, to imagine insuring their own lives. From an 18th century moment when insurable interest governed one person's right to own another, a person was now understood to have property in his or her own life. In the aftermath of Thomas McCargo's slave insurrections were no longer covered by insurance companies, as the door remained ajar for the rare possibility that enslaved persons might find occasion to seize their own destinies. In 1851, the formerly enslaved Reverend Noah Davis of Baltimore exploited an insurance policy on his own life as collateral to secure hundreds of dollars he then used to purchase his wife and 2 children who had been enslaved in Virginia. 4 years later, when he discovered that his eldest son sat in a Richmond jail, he took out an insurance policy that he exchanged for the boy's freedom. 2 years later, when he encountered his daughter at a Fredericksburg, Virginia auction, he convinced 2 bystanders to purchase her while he repaid them with a $1,000 policy on her life. Thus, while the idea of placing a monetary value on the life of a free citizen was still controversial in the mid-19th century, the point was so mundane to African Americans by that juncture that it was arguably inextricable from the way they conceived social mobility. This was as much the case for free persons as it was for enslaved workers. Some scholars have used the fact that a few mere thousand slaves were insured during the height of the slave insurance industry as evidence that planters were somehow disinterested in generating as much capital as they had available to them. But these scholars have not paid adequate attention to the way the institution of slavery was reconfigured during the domestic trade. As planters carefully bred slaves, hired them out, and had them trained to labor in emergent industries like railroads, steamboats, and coal mines, the value of slaves as capital would no longer be determined primarily by a given slave's physical characteristics. Instead, policies crafted during the domestic slave trade emphasized the slave's skill set. The most highly valued slaves were domestic workers with decades of experience and intimate knowledge about how to run a household, artisans like blacksmiths and shoemakers, workers with highly coveted expertise like butchers, coal miners, and clerks, and those who excelled in especially dangerous industries like railroad and steamboat workers. This means that slave insurance foreshadowed postbellum genres of industrial insurance, as owners of capital sought to shield themselves against the risk associated with the loss of an individual's capacity for labor. Since the industrial age, insurance, namely life insurance, has helped people to measure the distance from familiar modes of mutual aid. But it is also crucial to consider the opportunity the history of insurance offers to chart the politics of stratification that has defined finance capital in a post-emancipation era. After all, the same historical moment in which slavery was abolished witnessed an uptick in sharecropping and convict leasing, institutions designed to defend forms of wealth and privilege that suddenly threatened to come undone. Despite a similar emphasis on institutionalizing credit-debt relations, insurance appears benign by comparison. Even though insurance firms assign differential value to human lives, the birth of insurance is seen, along with the triumph of capitalism and democracy, as part of the birth of freedom. and yet the most thoughtful scholars among us have long been wary of this conflation. In 1898, W.E.B. Du Bois, then a professor at Atlanta University, edited a report based on the proceedings of the Third Conference for the Study of Negro Problems, which his institution had hosted on May 25th and May 26th of that year. This publication capped a 3-year, 3-part research investigation and inquiry concerning the mortality of Negroes in cities in 1896, another into the general social and physical condition of 5,000 Negroes living in selected parts of certain southern cities in 1897, and now an examination of efforts Negroes had been making to better their social condition. It is in the context of this report that Du Bois confesses a long-standing fear that the birth of black life insurance firms would spell the official demise of the mutual aid societies formed as indigenous mechanisms of security during legalized slavery. He also worried that newly emancipated African Americans would be readily exploited by insurance firms. As he cautions in his 1898 report, Negroes should be emphatically warned against unstable insurance societies conducted by irresponsible parties and offering insurance for small weekly payments which really amount to exorbitant rates, end quote. Du Bois was right that actuaries and underwriters would saddle African Americans with higher premiums, including those who worked for black-owned life insurance firms. Of course, the demise of Reconstruction meant that African Americans would ultimately return with renewed vigor to mutual aid societies, often in the form of social clubs or fraternities and sororities where members paid dues and pooled resources in times of crisis. Still, as we have seen, African Americans could only rarely, if ever, extricate themselves entirely from their monetary value in the marketplace. This was even more true of enslaved workers during the last few decades before emancipation. As I mentioned, in addition to breeding slaves, merchants generated revenue from the limited number of slaves available after the slave trade was abolished by shipping bonded workers to territories in the Lower South, often by steamboat, down the Mississippi River from Midwestern cities in Ohio, Indiana, and Illinois, or down the East Coast from Chesapeake Bay port cities like Baltimore to Gulf Coast ports like New Orleans. In the process, planters routinely took out insurance policies on their slaves to mitigate the potential hazards associated with transport. In urban locales like Virginia, where the demand for slave labor was high and the reserves were dwindling, workers were routinely hired out. As mentioned before, enslaved coal miners worked in one of the most dangerous industries and possessed one of the most highly prized skill sets. Of course, it is an axiom of slave insurance and of capitalism more broadly that the most dangerous enterprises are often the most profitable. The Chesterfield County mines are nestled in the Richmond Coal Basin. At a nearby location, coal was discovered in 1701. Evidence of successful extraction dates back to 1730 at least. As such, Virginia's Midlothian coal mines may well be the oldest coal mines in America. Midlothian coal mines got into commercial production in 1748. As these developments quickly generated interest in transporting this precious resource, the Midlothian coal mines also became the site of Virginia's first railroad. In 1825, Abraham S. and Archibald L. Woolridge established the mining firm A&A Woolridge and Company, in part by leasing land from Major Henry Heath. Major Heath, a British emigre to the U.S., settled in Chesterfield County, Virginia in 1759. Henry Heath fought in the American Revolution as part of the 1st Virginia Regiment, shooting through the ranks from captain up to major. In the later years of his life, Major Heath honored his Second Amendment right through duty to his state militia, but also became a successful businessman. Dabbling in tobacco, Heath would ultimately become most well known for erecting a family business at the Blackheath coal pits that was later taken over by his son, the Confederate General Henry Heath. The end of the transatlantic slave trade and the birth of the U.S. domestic industry enticed young Henry, who is often known as Harry, to make the most of his access to capital and land and slaves. According to state of Virginia tax records, Harry Heath only owned 20 slaves in 1801, but he was savvy, and an 1810 classified ad to the Richmond Enquirer proves he was interested in securing additional workers. wanted on hire for the balance of the year 30 or 40 able-bodied Negro men for whom a liberal price will be given. They will be employed in the coal mines. By 1812, young Harry Heath had successfully acquired 114 slaves. And while most enslaved persons were subject to harsh punishment and grueling work, coal mining was considered to be an especially dangerous industry. And its connection is worth noting that the Heath pits of Chesterfield County marked the first recorded explosion of a coal mine in 1810. There was another in 1818. Then on March 18, 1839, there was a particularly gruesome explosion as the Blackheath coal mine that resulted in the tragic deaths of 40 workers. 38 were slaves, though only the names of the two white mine superintendents were published in local newspapers. The Richmond Enquirer compared this disaster to similar trends in English coal mines, where more than 100 people had been killed between 1812 and 1815, though it concluded the report by citing scientific discoveries that were likely to reduce the rate of mortality. Despite the optimism that dominated mining ventures, coal mining continued to be an exceedingly dangerous enterprise. Some decades later, A.S. Woolridge submitted a petition to the Virginia General Assembly on behalf of his stockholders, fretting about the quote-unquote deadly hazards to which enslaved miners, as well as ostensibly free wage laborers, were subjected. The coal miner, he noted, quote, must encounter dangers at every stage, from the falling or crumbling of the roofs and pillars from the accidental fire, a tragedy that had twice occurred at the Midlothian mines, the Assembly was careful to note, from sudden eruptions of water flooding his works, from the fearfully destructive explosions produced by inflammable gas, and from the breaking of ropes and other accidents in the ascending and descending the shafts, a danger which will be better appreciated when it is remembered that every laborer employed in mining is at least twice a day suspended over a depth of many hundred feet, end quote. The report cited the presence of methane, quote, an odorless, colorless, flammable gas, end quote, that engulfed the quote-unquote poorly ventilated mines as the primary cause of these calamities. Even trying to investigate the source of a potential methane gas leak proved hazardous, as an 1876 article from the Rural Messenger stressed. Mr. Thomas Carroll, the foreman, was informed that the mine was filling up with gas and went down to the pit to see about it. He held in his hand an open lamp such as is commonly used by the pit hands. The moment he reached the bottom of the pit and started to go into the mouth of the shaft, the gas communicated with the lamp and a horrible explosion occurred. Or consider the 1836 Chesterfield County Circuit Court lawsuit in which the jury awarded the plaintiff, Mr. Hill, $400 because an enslaved worker he had rented to a Mr. Randolph for 1 year died in a coal mine after inhaling what the court brief calls impure and noxious air. Thus, mining was not simply hazardous to the owners of capital, whose profits could literally go up in smoke, but for enslaved workers who stood to die a slow, quiet death from imbibing poisonous gases. Still, these perils did little to slow the industry. Instead, eager industrialists sought insurance to protect their investments in their workers. In fact, slaves were not even sent into the pits unless they were insured. As internal correspondence at the Baltimore Life Insurance Company dating to 1857 reads, the parties who apply for the insurance of the coal pit hands are very anxious to get the policies, as they are keeping the hands, that is, slave hands, above ground and idle till they get them insured. Both the Baltimore Life Insurance Company and the Nautilus Insurance Company, the latter eventually acquired by New York Life Insurance, insured slaves at the Chesterfield County mines, and slaves were not insured unless they received medical exams. The health risks that derived from loose methane in the mines, what the court called impure and noxious air, was a constant concern. Why then did it take a protracted protest movement for ostensibly free coal miners to demonstrate the hazards of the industry? For more than 150 years, scientists had been aware that underground coal mining destroys lung tissue and leads workers to experience a dramatic decrease in the flow of oxygen to the bloodstream marked by chronic shortness of breath. What is now identified as black lung disease did not formally cohere as a medical illness until the end of the 1960s, and it required a bitter, protracted struggle against the government, the medical profession, and even their own union, to quote one expert. Coal mine workers had long suffered minor lung deterioration, sometimes called miner's asthma, but for a long time, this condition was considered an occupational hazard rather than an occupational disease, as it is now classified, the latter a question of liability for employers. When labor practices became automated in 1930, the quantity of coal dust to which miners were exposed increased dramatically, and yet workers were dissuaded from fighting for healthier working conditions since labor leaders had agreed to mechanization in exchange for increased wages and benefits. Further, miners had to transform how medical professionals, who had an incentive to side with their employers, viewed their plight. The medical specialists most knowledgeable about working conditions were employed by the very corporations the workers sought to petition. The industry was finally reorganized after World War II, yet workers still found it difficult to marshal evidence that could convince licensed medical professionals of the structural hazards associated with coal mining. Even the advent of x-rays for workers did nothing to alter the formal medical establishment's position. Finally, with the creation of Black Lung Association in 1968, workers, doctors, and grassroots organizers could band together in a formal organization dedicated to their cause, launching a series of strikes and education campaigns, which finally succeeded in pressuring the federal government into passing a Black Lung Act in 1972, which expanded the scope of evidence associated with chronic lung disease. By the 1980s, this movement succeeded in transferring liability for the health of coal mine workers from the federal government to private employers, and Black lung disease was finally classified as an injury that fit within the rubric of workers' compensation, even if regulatory agencies have at times confessed that it is quote-unquote virtually impossible to determine which mines are in compliance with established standards at any given time. In light of these dynamics, we might ask ourselves, what would have happened if the medical exams of slaves had been introduced as evidence for ailing 20th century laborers? For the most alarming aspect of life insurance as it surfaced in the decades following emancipation is that both the individual medical history and the salary that is the basis for the actuary's projection derive from confidential information. In other words, life insurance arguably constitutes the privatization of a calculus of value that had historically governed slave labor regimes. What does it mean that these dynamics accompany the ostensible birth of freedom? Is it not ironic that we sometimes have better information on enslaved coal miners than on coal miners whose lives might carry corporate-owned life insurance policies, which remain privileged information? In this sense, we might say that corporate-owned life insurance derives its legal force from a contradiction that defined insurance during the age of legalized enslavement. As I've mentioned, prior to the 18th century, slave insurance was permissible because the insured object didn't have legal status that citizens enjoyed. In the aftermath of Thomas McCargo versus New Orleans Life Insurance Company, the formal legal rationale was that ownership of a worker equates to ownership over another person's risk. Thus, 19th century legislation would trace a line from the 1774 language of insurable interest to insurance in workers. Yet what about the related point, that insurance in another person presumes that the insured enjoys compromised legal standing in the polity? This was held to be the definition of unfreedom. Is that an adequate formulation for thinking about 21st century labor relations? Actuaries frequently tie the legal justification for corporate-owned life insurance to the 1881 Supreme Court case of Warnick v. Davis, which specifies that the doctrine of insurable interest applies 1. In the case of individuals related closely by blood or by law, a substantial interest engendered by love and affection, and 2. In the case of other persons, a lawful and substantial economic interest in having the life, health, or bodily safety of the individual insured continue, as distinguished from an interest that would arise only by, or would be enhanced in value by, the death, disability, or injury of the individual insured. Of course, recent revelations of multi-million-dollar corporate-owned life insurance policies would seem to undermine the legal rationale that a corporate-owned life insurance policy restricts an employee from being, quote, enhanced in value by death, disability, or injury. That you can leverage an employee's risk factor as a way to generate wealth offers a more complicated portrait of human capital than we are accustomed to seeing. This research also suggests that even people who do not see themselves as the descendants of enslaved persons from Africa are implicated in forms of valuation forged during the age of legalized enslavement. The evidence is all around us. In 1987, at about the same time that coal miners finally secured the right to proper health care and safety mechanisms and adequate notice of the risks their enterprise entails, material evidence of the subterranean trajectory connecting these free workers with their enslaved brethren came to light. While breaking ground on a new site, developers discovered a small family burial plot alongside the Midlothian Turnpike. Their initial plan was to somehow preserve it, but as construction unfolded, they happened upon a cemetery 4 times that size. Forensic experts identified the inhabitants of the mass grave to be people of very modest means, and the proximity of this burial ground to Chesterfield County's Midlothian coal mines indicates that it was a site where expired slaves had been dumped. But consider that these workers shared earth with a white family. A Chesterfield County Planning Department document from 1983 referred to this plot of land as that of a slave cemetery located in close proximity to that of whites. All told, 226 bodies were recovered from the mass grave, an eerie figure insofar as it marks the number of years Chesterfield County mines had been in service from the time coal was discovered in 1710 until 1927. But you don't have to believe in omens to appreciate the subterranean trajectory that links slave insurance and life insurance, the shared predicament that encompasses people of diverse demographics, and the struggle that continues to adjudicate the monetary value of a human life. Thank you. So I'd be happy to take questions.
I think we have some time for questions. I should also remind everyone that if you are one of those individuals who has 1 foot in the real world and 1 foot in the Twitterverse, is that what it's called? We tweet from @IRAAS-AAADSColumbiaU. So that would be the handle there. And I think we can, I'll let you.
Yes, sir. I'm happy to take questions. If there are no questions, I'll call on people. Sir, in the middle.
From your studying all of this about the insurance slave, could you draw a conclusion as to whether, I think, whether the...
Sir, we're recording here, so we'll need you to speak in the microphone.
Whether the costs, whether you could use this knowledge that you got from this study to measure the cost of life insurance on the 100 young black men who were arrested on July 4th, less than a mile from here. And would that cost of the policy be increased or decreased by the fact of there being, one of them, offered imprisonment for 18 years?
Okay, so if I understand your question correctly, it has to do with how would I, like in terms of how life insurance works, how do I think about the value of the life of, for instance, like African American men who are being arrested and imprisoned, or African American men in the criminal justice system? It's a great question. I actually think that it articulates with what Dr. Sam Roberts was saying.
I can't hear you.
Sorry. Your question, I think, draws upon an insight Dr. Sam Roberts was developing in his introduction, where he said, you know, on the one hand, this paper might not seem to have to do anything with the Eric Garner case or related cases directly. On the other hand, it raises some of the same issues. I think it is striking that, like, it may be obvious that, say, in the context of enslavement, people were bought and sold and insured. It's harder to understand how the idea of life insurance articulates with the logic of a free society in which everyone is ostensibly equal. And the idea that we are each equal to each other is interesting because from the perspective of an actuary or insurance company, we're by no means equal. You know, like an actuary could tell you based on your family medical history and your projected future earnings how much your life is worth in the marketplace. Or if you're in a car accident and the person who's liable for the accident is given a judgment, they will quickly come up in a matter of minutes with a figure of how much that person should pay the family. And so I think your question raises the point that some people's lives are worth millions and millions of dollars. Other people's lives seem to be worthless, right? Other populations seem to be disposable. And I think that the sort of prison boom illustrates that point, although from another perspective, it's as if those lives are valuable in the aggregate for very specific economic and political projects, whether it's using convict labor or it's, as you know, in some places, even where felons have been disenfranchised and denied the right to vote, they still count as the population that an elected official can draw upon as part of his or her constituency. Or, you know, in some states, you know, prison construction is a booming industry. So I actually think that your specific question, those men's lives might not be insured at all. You know, it's likely that their lives aren't insured at all.
They might not be what?
Insured at all. You know, in other words, like.
I mean, could I go out and buy an insurance policy on my son if he lived in Grant houses? You'd say that they wouldn't write me a policy.
Yeah, I think you could buy a policy on your son. I don't think you could buy a policy on someone else unless you were apparently in Rhode Island, in which case that person could potentially sell you their death benefit if that person has one. But, you know, the sort of tension with insurance is that we generally understand it, and we're led to understand it as something that we own as our individual property. But there are all kinds of examples that sort of counteract that sort of prevailing assumption. So, thanks for your question, Sam.
Thank you so much. This is a lot to think of. I want to be clear that when I said I was considering that we reschedule, it wasn't because I thought this had nothing to do with it.
Oh, I know.
Yeah.
No, I think, no, it's because...
In fact, the reason because I suspected, and you proved me right, that this has everything to do with the historical trajectory of how we value, or how we value life now and how we have in the past, and how it's tied to the political economy. Well, how is it tied to political?
Right, exactly. No, I understood you to be saying that you otherwise would have wanted to cancel it, but in fact, you felt like it resonates so much with what's going on that you thought it was important to have it.
My first instinct this morning after hearing the verdict yesterday evening and everything that was going on was just because there's so much going on right now. So I just want to be clear about that.
Right.
You've actually given us a lot to think about. I want to thank you about that. My question is, and in some ways it dovetails with the previous question. There's something about this trajectory that you've elaborated for us where the industry of insurance is a projection of lifespan, right? Obviously.
Yeah.
And so in that there is a certain individual futurity. You even have free African Americans buying policies on themselves, then selling the policies that they can buy, therefore, the freedom of their family, who in turn, because they are free, would be able to insure themselves. It's a kind of very strange cycle there. Right. But there's also something in, I think you said it was the McCargo case, was that?
Yeah, Thomas McCargo versus...
And that was the Creole?
Slaves Creole.
And the Hermosa?
Right. Well, not the Hermosa, but the Creole, yeah.
It was the Creole.
Yeah, the Creole.
All right, great. But the Hermosa case was the year before that?
Yeah, the Hermosa case sort of inspired the Creole insurrection.
Right, okay, great, thank you. There's something about that where after which they decide, or the courts decide, we no longer will, or I guess the insurance companies decide, maybe you can clarify that, we will no longer honor a policy if the person insured under it has died as a result of a slave insurrection. So there's a lack where we have an individual economic futurity, where people are banking on their own futures, or in many cases, as you noted, banking on the futures of others with whom they have no affiliated ties whatsoever. Right. But on the other hand, there's a very interesting ignorance of political futurity. Right. So there's no imagination on the part of insurance companies that, we're going to insure this as long as they live, and our actuarial table say they'll live for another 23 years. But there's no political futurity, no political imagination that says, or a moral imagination for that matter, that might say, this whole slavery thing ought to go in the dustbin of history. Right. And so there's my supposition is that it's a classic tale of capitalism being an individualist enterprise. But I haven't researched that you have. No,
it's a great question. Yeah, I can elaborate a bit. I mean, I think that on the one hand, as you point out, it seems to lack a kind of moral imagination. On the other hand, you could say that the way insurance works is the byproduct of the moral imagination of capitalism, which is not about necessarily that. It's contradictory in the sense that it's the governing logic of the given person in question that, like, so, okay, technically perhaps a slave might be a human being, but the legal status of a slave is as someone else's property, and therefore that person doesn't have agency, and therefore the person can be owned, right? But not only is it the case that the person is apparently a human being if the person exerts the kind of agency a free human being would exercise, but at a certain point it's apparent that it no longer becomes tenable to hold human beings in the position of assets or property because they create too many complications for an emergent economic system that's based on voluntary contractual decision making. So therefore you can no longer have a whole category of human beings who are legally denied the right to exercise human agency, and so then owning someone else or sort of securing the monetary value of someone's life would have to then be established on other grounds, right? Now, some people would think it was eradicated entirely, right? In other words, so the idea that slavery is outlawed would suggest that you cannot profit from another person's life, but in fact you can, but only on the grounds that now you own the person's productive capacity, not the person's body itself. You see what I'm saying? So it's part of the moral imagination, to use your phrase, a very astute phrase, moral imagination of capitalism is that you can own someone's skill set, you just can no longer own the person or something like that. And so I guess the morality of it is often tied to sort of the efficacy of a particular economic or political project. I can give you an example. Another example, I would say. So, for instance, we often think that that death or something is outlawed or something. It's illegal in a kind of modern, free, enlightened society. You know,
what's illegal?
like death, like certain kinds of killing. So, human sacrifice, for instance, was like something that a lot of European societies in the colonial period explicitly sought to extinguish in territories they controlled. And they would cite the practice of human sacrifice as evidence of a primitive logic, and they want to establish a modern, rational market logic. And yet some of the wars they launched against these very societies resulted in the deaths of soldiers and people in those societies. And yet warfare is seen as a form of extinguishing life that is wholly legitimate and sound, as opposed to human sacrifice. So the net effect of those two systems could be the same. The same number of people could be dying, and yet it's the moral logic driving it that's understood to be the basis for its legal validity. You know what I mean? So, in this regard, it's interesting then. And so, modern enlightened societies have certain ways of extinguishing life that are wholly legitimate and legal, and other kinds of societies are understood to have other kinds of logic that are not legitimate. Like war is not the same as terrorism, you know, because war is understood to be a sort of form of extinguishing life that has a legal justification and basis for it, while terrorism is supposed to be tyrannical and a suspension of the law, so to speak, right? But then who gets to decide whether it's a war or a terrorist attack, or whether a terrorist attack is part of a formally sanctioned war or not? This is the sort of broader moral imagination and sort of juridical foundation of society that we're debating, you know, and which
Both
is
have their own kind of symbolic economies of martyrdom.
Right, but
Even though we don't talk in terms of the U.S. military, we don't use that language at all.
Right, and they're not seen as equivalent. Like one could be seen as wholly illegitimate, another one could be seen as wholly legitimate, and this is why often when there is a sort of form of extinguishing human life that would otherwise be controversial, it's justified on the grounds that the life extinguished was not part of modern enlightened rational society anyway, which is why you could have, you know, that's why like in the sort of build-up to many military campaigns, the society that's the target of the military operation is framed as barbaric and tyrannical and despotic because its life in that society is not worth the same as it is in a modern enlightened civilized society, which is also why even in defenses of extinguishing life, that same rationale creeps up, like in Darren Wilson's testimony that he saw a demon when Michael Brown stood before him, he saw a demon and a monster as opposed to unarmed teenage boy or something like that, right? So, all right, this is a great question though. Other questions? Sam?
My name is Chris Wallace. I'm a senior at Columbia in college. I had a question regarding the monetary value of human life. As there also is a monetary value I see for the potential for human action and success and prosperity, and I was wondering if you've seen or if you can identify any sort of strategies for seeking redress or reparations for the stymied success of the black community, also black males, given mass incarceration. So not only sort of preventing that institution from continuing, but also seeking redress for the effects of it beyond affirmative action.
Okay, I'll try to rephrase your question to make sure I understand it. Is your question whether, if insurance is a form of sort of finance capital, a financial mechanism that generates tremendous profits, is it there a possibility to use certain strategies involving finance to either seek redress,
Exactly.
or to generate wealth for marginal populations or something like that?
Exactly.
Oh, that's a good question. Yeah. So, my favorite example is, Ida B. Wells was forcibly removed from a train car and sued the train company and won at a lower court and lost at a higher court. And we know Ida B. Wells as a journalist and an activist and organizer, and she's very prolific. But it's interesting that, she sought redress through a lawsuit and saw that as a kind of civil rights strategy. And it's also interesting that, a lot of racist labor unions, when they were finally desegregated, it was not merely that there was civil rights legislation afoot or that they were sort of being exposed for their racist practices, is that many of them feared being sued actually for discriminatory practices. So there is a way in which lawsuits have become a civil rights strategy. And we see this, in fact, tort law is sometimes the sort of last, hope for some sense of justice for people who lose cases that otherwise, people who seem to have been injured in a way that's obvious and readily apparent, and yet lose a criminal lawsuit. A civil lawsuit often emerges as the sort of next best hope for some sense of justice, right? So, in the Rodney King case or other cases, it was the civil suit that delivered a multi-million-dollar penalty against the police department, but the criminal suit, the cops were not, charged with the crime, for instance. So I certainly see that as a strategy that people will deploy from time to time. The problem, obviously, as we see in the sort of debate about grand jury indictments, is that precisely by nature of the law and precisely because legal reasoning is, subjective and contingent and episodic, it's not likely to provide a sustainable solution to social problems, although it is a kind of momentary solution for a particular kind of injury or something like that.
And how far back can those redresses go?
I guess is your question that was the earliest evidence, for instance, we can find of lawsuits as a strategy of seeking redress,
or in terms of present day circumstances for the Black community? How far back can they go in terms of the historical implications of sort of oppression? So.
Yeah, it's such an empirical question. What's the earliest example we can find? I think part of the challenge, and especially the early challenge, say for someone like Ida B. Wells, is that, to be victorious in a tort lawsuit, you have to prove injury, but you also have to prove that you have attained what's going to be construed as kind of modern legal subjectivity, right? So, for instance, in the context of legalized enslavement in the U.S., there are laws in many places like a slave's testimony is not valid in court, and the only way the testimony can be used if there's a white person who saw the same thing who could affirm that testimony. So, if you don't even have political subjectivity, you can't sort of be a successful plaintiff in a legal case, right? And even when Ida B. Wells won her initial lawsuit, the headline was like, "Darky Damsel wins lawsuit," right? So there's even a kind of broader skepticism about what it might mean for her to have been injured, because, if she's not even human in the same way, how can she be injured or feel pain in the same way? So, and not to be crude, but just to suggest that, and this is why there's so much concern about sort of contemporary court rulings and about whether they affirm or sort of disaffirm the humanity of African Americans, because there's a kind of question about whether they can ever really be entitled to the same kind of justice, same quality of justice. Other questions?
Actually, I have another one.
Okay.
Sorry.
No, that's fine.
I think you touched on this a bit, but I wondered if you had some other thoughts or comments about it. There, in the late 19th and early 20th century, one of the major debates about racial science involves two white insurance actuarial scientists. You probably know them, Frederick Hoffman and Lewis Dublin, from the Metropolitan Life Insurance Company and the Prudential Company, respectively. And I believe they're both in existence, unless one has been bought out by AIG or something. I'm not quite sure. And what that debate revolved around was the physical uniqueness of the black body, and whether or not it constituted a different species, and what diseases were either unique to African Americans or at least had different manifestations. And it led on one hand for Dublin, who was more of a liberal, and I believe had a friendship with people like such as W.E.B. Du Bois, to say, these differences that we talk about are probably overblown, but probably differences of environment, such as bad housing in the modern industrial, the urban setting. Whereas Hoffman was basically a eugenicist of sorts, and said that black people were different, and as a result, his company would not insure black people at all. Is there, my understanding, which is a bit limited, is that this is the first century where we see actuarial scientists entering this debate about racial specificity. But you're tracing this history of at least insurance companies insuring black people and insuring slaves way before that. Does that ever come in? Do we ever have an insurance company saying to a slave owner, well, we'd like to insure at this rate, but we all know that black people die more quickly of various diseases, and so we're going to give you this lower rate, or maybe not insure?
No. I mean, it's interesting because it's a good question. So first of all, I think the question captures something that I'm trying to develop in my research, because it's been an oversight in two different literatures. So in the history of slavery, for instance, people are aware of the fact that slaves were insured, but they often generally assume that slaves were insured as cargo, like historians. Or in the history of life insurance, they are aware of the fact that insurance companies were skeptical for a long time, at least until slavery was abolished, and often even afterwards, as you point out, about whether it makes sense to insure African Americans. And often the logic they cited, which was in their view not evidence of racial discrimination, but just sort of good science, that at the dawn of emancipation, black life expectancy is lower, obviously, and they suffer from all kinds of health complications that have to do with the condition of enslavement, so they're not necessarily a sort of great investment. But at an earlier moment, like insuring an enslaved was not seen as insuring an African American, because it wasn't seen as life insurance, it was seen as property insurance. But the irony, or sort of the paradox I'm trying to tease out, is that if a slave had worked in the railroad for 10 years, that slave was more valuable than a slave who had never worked in a railroad to a railroad company, and they would insure that slave for a higher amount than they would insure a new slave. So they already had appreciation for the fact that someone's skills could accrue over time and that someone could develop expertise. And particularly when you think about someone enslaving the person who manages his or her household, they obviously had a sense of leadership, expertise, insight, right? They saw the person as a manager, and there are two different kinds, to sort of tie to a contemporary example, there are two different kinds of corporate-owned life insurance. There's one that's called like dead peasants insurance, janitor's insurance, where someone insures rank-and-file employees in the aggregate. And the other one is called key man or key person insurance. We insure a top executive, where a hospital could conceivably insure like a top surgeon or something like that. And it's as if slave insurance is more like key man insurance or key person insurance. They're essentially saying like, this person is so valuable to the production of this industry that I'm going to make sure I secure this asset. So in that sense, there was not a debate about the interiority of the slave or that person's inner humanity, because there was an assumption that it was beside the point. I mean, they would conceive of the slave in the legal category as property, but in fact, they were attentive to the expertise this person has accrued, And so it's a way in which like traders were ahead of the curve. They were ahead of legal theorists or ahead of politicians in thinking about what had happened to African Americans, because really, it's, as I say, it's after the slave trade ended in 1808, it's really in the decades following that people start to realize, well, okay, so no more slaves have come in, and some slaves are being rented out, right? And as they're being rented out, they're acquiring expertise, and now they're some are more valuable than others. So they've grown and they've learned and they have skills that others don't have. So it's as if the logic of slaves as inert property was breaking down around them, even if the self-consciousness of that took longer to gel. Does that make sense?
Right. There's a contradiction there between insuring property versus property doesn't get experience.
Right. Property can't improve its skill set over time.
2005 Honda is more valuable because it's been on the road for 9 years.
In fact, it depreciates over time, right?
Yeah.
So essentially they're talking about skilled laborers or laborers who they're conceding that these laborers are cultivating expertise, even though the legal category in which they reside is still that of property. So,
Bizarre.
Yeah. Question?
I guess I'm just curious if doing this research and looking at all these different factors has made you change or rethink your outlook on the definition or your definition of someone being owned?
Yeah, I like that question a lot. I think it does, because I think certainly it changes the way one might think about slavery, for instance, right? Because I think often when you think about slavery, you think about someone being beaten with impunity, whipped to death, treated as an object, as an animal, as livestock, and that of course happened. And of course most slaves would more likely to be in that category. So the plantation slaves, particularly in contexts that were really lucrative, they were sort of worked in that way. But I guess the idea of slaves having acquired expertise, what's interesting is that the more expertise a slave acquired in an emergent industry like railroads or steamboats, the more mobility that enslaved person experienced, and the more valuable that person was to the owner. And which is why, there are sort of illustrations of this that we can revisit once we're aware of this phenomenon. Like if you've seen the film 12 Years a Slave or read Solomon Northup's autobiography, The Slave Diary, you see that he has more mobility than his peers, and it's because he was a carpenter and a carpenter's apprentice. So he'd walk to work. There's a sense that he's well educated. He has these skills. He's cultivating them. He's of value, of immense value. And even the moment when someone threatens to lynch him and wants to lynch him, that person can't lynch him because he's mortgaged to someone else. And unless the person is really willing to cover the value of his life, that person cannot lynch him, right? So it's kind of striking then to see an example of a slave who was actually valuable in a way beyond the sort of immediate productivity to be gained from working, in a coercive context. And to answer your question, it does make me wonder just how much of what a person means to a given corporation today has to do with being owned in a sense, right? Because you may know how much you earn for your company on a daily basis or on an annual basis, and you know how much you're being paid, but you may or may not be aware or may or may not think about the fact that your firm has a policy, an insurance policy out in your life, in which case it is as if your very being is tied to this firm's prosperity, which is an uncomfortable and disconcerting experience, but in a way that I find productive, because it means that we are still grappling with the question of what it means for someone to have monetary value in someone's life more than a century after having formally abolished slavery, right? And it's also pretty clear that as soon as a law is passed, so there's a legislation that was passed in 2006 called the Pension Protection Act. I think that some congressional officials who are aware of this practice have passed laws saying now that the company has to stipulate to the employee if it has a policy in his or her life. But all that's led actuaries to do is to find innovative ways and sort of retool their policy. So just as fast as you can pass a law trying to extinguish the practice of generating wealth from someone's life, someone's finding another way to do it on legal grounds, or someone's looking for this sort of legal gray area in which to continue with this practice. And I think that's an important insight to hold on to, right? That it's not as if you ever pass through a threshold in which someone will not be seeking to gain advantage over someone else. It's as if there's a constant effort either to sort of exploit someone else or gain sort of economic leverage from someone else's life, or demean someone else and treat someone else as not having quite the same humanity. And that is the significance and importance of, say, protest politics and reform and sort of liberal scholarship, which is to sort of interrogate those practices that seem morally dubious or problematic. But that's a great question. Thanks. Any more questions?
If you don't mind.
No.
Why not?
Yeah.
There's a period in the 18th century where we have indentured servitude, and whereas they are not slaves, obviously, but they are property, at least kind of in a morphology similar to slaves, in the sense that a landowner would pay the British Crown for the use of this individual for a period of 3 or 5, I think sometimes more, but typically I think it's like a 5, maybe 10 years and some later on. If the vessel on which they are transported from Liverpool or wherever to Virginia or the Carolinas sinks, was there anybody insuring them, or just the Crown just eat the cost of that and say, here's your money back, or they won't collect money? Do we have a parallel case as a company?
Oh, I see what you're saying. Is there a parallel case to like the Zong case where a boat of indentured servants might have died, and someone collected on their death. Yeah, I'm sure that happened. Actually, I'm sure that happened. We would have to know about this particular vessel, but I'm sure. But I guess I'm sure that indentured servants could have been treated as cargo, and the value of the aggregate, the value of the ship of indentured servants seen as a kind of investment that one could secure. I think what made the Zong case so distressing to people first is when it happened, sort of like 1780s, just at a moment when abolitionism is gaining momentum, right? And so by then there are already plenty of people who believe that Africans are human and don't deserve the treatment they're receiving. And in the Zong case, it was that the slaves were getting sicker and sicker, as you know, and the captain threw them overboard. So it wasn't even as if the ship went down and you collect insurance. It's like, okay, they're worth more to me now, dead, as abandoned cargo than they are as sick human beings who can't be sold anymore. And it's sort of that raw calculus being brought to the fore that I think really disturbed people. But the more general sense in which someone could be valuable, we've sort of held on to that. That still has traction, obviously. And so I think that's also, I guess, a contradiction or a paradox surrounding the case, which is on the one hand, people could be aghast at someone's crude economic reasoning. And on the other hand, the idea that we're all equal or something, and that somehow people don't see other people as valuable for their own means is just kind of beyond naive, right? So I think there's this tension that, this paradox that I think we're still grappling with.
Well, yeah, the indentured servant I don't know if it said 18th century, I would say 17th century, would have been imminently uninsurable for life insurance purposes.
Right, because their
their life
status.
expectancy is basically 3 years, 36 months, maybe 5 years.
Right, they wouldn't have had.
Horrible rates of mortality.
Right, and they wouldn't
But
have.
as cargo, they might have been valuable.
Right. So for a voyage, they might have been valuable, but yeah, it certainly wouldn't have made sense to apply a policy to their lives. Which is why this is why life insurance comes about when it does. Really, in the U.S. in particular, it's like 1840s. It's like it's sort of at the horizon of a society in which all people will ostensibly be free. You can then establish a calculus for deciding how much value you could project from their differential living experiences, and then come up with a sort of pool in a way to assess risk. But I think that it raises the bigger question too about whether that's a plausible economic strategy or philosophy for a society. Because, some people will say that the source of the economic crisis in 2008 was really the derivatives marketplace, which essentially is a form of insurance, right? And as one economic sociologist said to me, if you can come up with a probability for something, you can come up with a kind of derivative for it, right? But if all these different probabilities are proliferating and capitalized, and if there's not an adequate store of wealth upon which people can cash in, it creates a bubble that can ultimately contract and cause all kinds of economic havoc. So I think the proliferation of insurance policies without sort of adequate attention to what the implications are is actually can be the source of a lot of problems for any given society. And it's certainly the case that insurance continues to proliferate, right? And I think it also has kind of tangible social and cultural consequences. Like, I once was going to host an event for visiting a scholar, and it happened to snow that day at NYU, but we had keys to the building, and I emailed people, they still wanted to come, so I said, okay, so let's have the event anyway, right? The speaker was already on his way, he's on the train on his way. So we get to the building, and the super says, oh, the building's closed. And I said, oh, it's okay, we have the keys and everything, we'll just have the event anyway. And he says to me, well, you're liable, if anything happens, you're liable. And I thought to myself, well, first of all, I'm not. But second of all, what does it mean that, as far as he's concerned, the crucial question is liability. Like, he does not want to be sued, does not want to. And so it's interesting that idea of liability, of potentially facing a lawsuit that one does not want to have to pay, can govern even the way one interacts with other people and stuff like that.
My fourth question would have been about the parallels to the 2008
economic crisis.
Yeah. So I'm glad you saved me.
Yeah. Well, just real briefly on that. So Michael Moore was aghast about the idea of corporate-owned life insurance, and he says, there's a reason why I can't take out an insurance policy on your house, right? Because I could just burn your house down and collect, right? So you can only insure your own house. But some people have described the derivatives marketplace as if 30 people have an insurance policy on the same house, And so when they all go to collect, that's what causes sort of contraction in the marketplace. So it's actually interesting. It's a productive example to think through in terms of how insurance works. Yeah. Well, thank you. One last question.
Oh, please. Pastor Thomas, yes.
Let me apologize for missing most of your talk, but I just want to ask whether the story you're telling about insurance is a story that is inviting us to think about slavery in particular, and perhaps more generally about the African American experience outside the property paradigm, right? Mm-hmm. And it seems to me that, and you can tell me if I'm right, that the shift that the focus on insurance permits, and that you're inviting us to make analytically with you, is from propertization to financialization. Is that?
Yeah, I think that makes a lot of sense, because I guess certainly the paradigm of property is inadequate. It's not adequate to explain either how slavery worked or how capitalism works. And finance brings with it the idea of projection and anticipation and calculus, calculation. So I think sort of crucial to the story is the role of actuarial science and mathematics and sort of projecting life possibilities. So this is why, you could argue that even financialization, or what we might call an actuarial logic, is not reduced even to insurance or to financial mechanisms exclusively, right? It's the same logic as someone deciding that based on the neighborhood in which you grew up, there's a statistical probability you're likely to wind up in prison. And people cite these statistics all the time. Or based on the school you went to, the likelihood that you'll go to an Ivy League school or something. And so people regularly trot out statistics that have to do with a statistical projection of who a given person is, or what happened based on the profile of the person. So this idea of sort of, what I would call sort of forensic profiling is not just limited even to financial industries anymore. It's sort of part of education discourses, crime, law and order discourses, insurance. Okay.
So the logic you're describing is one that has proliferated in the age of racial neoliberalism, in effect.
Right, yeah. And I think it's precisely because the legal category, the group that enjoys compromised legal standing at a given moment, that group, so African Americans have had traction in that category, but obviously other groups can be included in that category as well. So I often think of it, we could say it's racial capitalism or sort of a racial infrastructure, but I often think of it as a kind of, I think capitalism, I talk about it as kind of forensics of capital or something like that, because it has to do not merely with race, but it's like race, residence, family, occupation. There's all kinds of sort of characteristics. So I think of it in the way that, like, when you fill out a passport application or sort of job application, all the different criteria you sort of cite, or a credit profile or something like that. There are all kinds of strategies of profiling, essentially, what you're talking about, I think, strategies of profiling. And so I would say something like, yes, I'm talking about financialization, but I also think it opens itself up to understand the way that sort of profiling has been sort of pivotal to governance since the 19th century, because there is a kind of interesting overlap between the birth of financialization, the birth of passports, the kind of ideas of how to trace and profile and surveil people, and then forms of sort of social organization, whether they're economic or political, that are tied into that. You might think of a credit card as a financial instrument, but if someone commits a crime and then goes missing, and the authorities are trying to find the person, the first thing they'll look to see is where and when the person used that credit card, right? So the credit card is not merely a financial instrument, but it's sort of part of a kind of mechanism of surveillance as well, or something like that. So it's interesting to think about the sort of history of surveillance and history of profiling, history of credit, and sort of the demise of slavery as being sort of occurring at a historical conjuncture.
Thank you.
Thank you.
All right, I think with that, I'd like everyone to join me in thanking again Professor Michael Rao for joining us this evening.
Thanks for coming.
Please check IRAAS.com for, I believe, our lineup for spring of next year should be up there. We'll be having many more events and some symposia. And again, we tweet from at IRAAS-AAADSColumbiaU is what it is. And please have a safe and restful end of the year and New Year. I believe we have some refreshments outside as well. So thank you so much again for joining us.